In a pre-trial question and answer session known as a deposition, is there ever an instance where I will tell my client to stop talking? You want to know the answer? Come join me for a walk downtown Manhattan as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is yes. There are instances where I will go ahead and tell my client to stop talking in the middle of an answer. Now, why would I do that? I'll tell you why. Because a pre-trial question and answer session known as deposition, by the way, lawyers also call it an examination before trial, is an opportunity for the defense lawyers, the attorneys who represent the people whom you have sued, to learn lots of things, lots of information from you, the injured patient, the injured victim, about what happened in your own words. The defense attorneys are going to question you for hours and hours. They have a maximum now of 7 hours in which to question you. During the course of questioning, you will often know and get a feel and get a rhythm for what types of questions they are going to focus on. You will often recognize and understand the question that they are asking you before they finished asking the question. So now, in your rush to answer the question, you now not only answer the question, but continue to explain the answer, even though the defense attorney didn't ask for an explanation. Even though it was a simple yes or no question. Hey, Mr. Jones, on this date, did you see the doctor? It's either yes or no. The attorney didn't ask you what prompted you to go to the doctor. The attorney asked a simple question. It's a yes or no answer. Instead of just a yes or no answer, you proceeded to give a long-winded explanation. In that instance, I may turn around and say, Mr. Jones, please just answer the question. Now, if you do it again, I'm going to interrupt and say, she didn't ask you that question. She only asked you X, Y, and Z. So please answer that question. And now you should know something else. When we go ahead and prepare you for this pretrial deposition, one of the important things that we discuss is the importance to listen to the question and then to answer only the question you are asked. If the attorney wants to ask about follow-up, if the attorney wants to ask questions that lead further down that path, they will certainly ask you follow-up questions. But to go ahead and volunteer that information thinking that the more information you provide, the better your case will be, is a big no-no. Because that's not necessarily true, and it's going to keep you there longer and longer and longer. Why? Because you're not listening to the question that they are asking. If you are paying attention, and you know in the back of your mind that there are certain explanations that you would like to give, there are some limited instances where it would be important for you to go ahead and give those limited explanations. For example, if they ask you about conversations that you had with certain critical people in the case. Now, if you don't share that information with the defense attorney, no one's going to know about it. So in some limited instances, it may be appropriate for you to go ahead and explain about conversations that you had with certain people. However, for the most part, answer only the question that is being asked. I promise you, the defense will ask many, many follow-up questions, and they will probably get to the point that you are trying to make in your long-winded explanations. So getting back to the title of this video, is it ever appropriate, or will I ever stop my client in the middle of an answer because they are talking too much? And the answer is yes, and I've certainly done it. Now, does it happen often? No, it does not happen often, but it is critically important to listen to the question and then go ahead and answer just the question that you are asked. And doing that will help move your case along and move the questioning along at a much faster pace than to explain away every single answer that you give. So why do I share this quick information with you? I share it with you just to open your eyes and help you understand how these types of cases work in the state of New York. You know, I recognize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York, and you are thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.